Carrie and Ugo, are you ready to get started?
Yes.
Wonderful. Well, hello everyone. My name is Kim Heinrich and I handle marketing for Meritas. I would like to welcome everyone to today's Meritas Capability webinar, the Foreign Corrupt Practices Act, What Clients Need to Know and Why. Our webinar today is scheduled to last for 60 minutes, and our presenters are Meritas members Carrie Scarlett of Goulston and Storrs in Boston, Massachusetts, and Ugo Cuesta of Cuesta Campos y Asociados in Mexico City. Ugo's practice focuses on international business transactions, and his extensive corporate background comprises foreign investment, M&A, finance, business, compliance, and corporate law. Since 1990, he has developed substantial expertise representing leading foreign entities doing business in Mexico, as well as Mexican entities doing business abroad. He has acted as lead Mexican counsel in several international projects and business transactions, advising multinationals on their legal, corporate, and finance structure in Mexico. Additionally, he's acted as lead counsel for the Mexican operations of assembly plants since their startups. And our co-presenter, Carrie Scarlett, again with the Meritas firm, Goulston and Storrs in Boston, his practice focuses on business law and international trade law, with particular expertise in assisting technology-based companies. He serves as general counsel to companies and entrepreneurs, providing guidance in connection with international trade matters, including effectively navigating the Foreign Corrupt Practices Act, the Export Administration Regulations, and the International Tariff and Arms Regulations. Now, before turning the webinar over to our first presenter, to Carrie, I'd like to walk through a few housekeeping items with you. And as you've all likely noticed, your phone lines are muted. However, we do encourage you to interact with our presenters using the chat feature, and that is found on the left-hand side of your screen. If you should experience any technical issues, please don't hesitate to hit the *0 on your phone at any time, and someone will be on the line to assist you. So with that, Carrie, are you ready to get started?
I am. Thank you, Kim. Welcome, everyone. We're very excited, Ugo and I, and Kim has been instrumental in putting this together. So we want to thank Meritas and welcome all Meritas members and others that might have dialed in. Today we're going to cover the Foreign Corrupt Practices Act, as you all know. I wanted to just give you a very brief overview of the discussion topics. We're going to start with an introduction from Ugo, trying to set the table and give you a little bit of perspective about not just the FCPA, but international efforts and treaties designed to combat corruption. Then I'll take the helm again and provide a kind of nuts and bolts overview of the Foreign Corrupt Practices Act. There's a lot of detail that we could go into there, but we'll keep it at a fairly high level given limited time. Then Ugo will pick up again with discussion of the extraterritorial application of the FCPA and facilitating payments. And he will also address a couple of case studies, so we'll put what we're discussing into practice, so to speak. And then I'll wrap up with best practices and suggestions on how we can help our respective and mutual clients comply with the FCPA and similar regimes in other countries. And then finally, we'll have a few minutes at the end for questions and answers. So without further ado, I will hand this over to Ugo.
Thank you very much, Carrie. Thank you, Kim, as well for the introduction. I have to admit that it's kind of weird to be presenting to an audience whose face I cannot see, but I guess we're even because you cannot see my face either, even though my guess is that you don't lose much anyways. But let me start by explaining to you why Carrie and I, as well with Meritas, selected this topic related with the FCPA. Pretty much the reason is not only Carrie and myself, but a number of other attorneys who we have been involved in international business transactions. We have perceived a significant increase on the awareness level of the damages caused by corruption worldwide. And not only that, but also we have seen a significant increase on the enforcement actions of anti-corruption laws in various parts of the world. Well, as some of you might know, and I'm seeing your names here, some of you attended this same presentation in New Orleans, so I guess, Carrie, that we can say that we are back on stage by popular demand. Having said that, I think that as a setting up of the table for Carrie's presentation and introduction under the overview of the FCPA, I think it is important to keep in mind the urgent need to reduce corruption and increase the enforcement of laws enacted to combat corruption worldwide. So we thought we could use these figures that you see on the slide now to remind us of the devastating effects of corruption. So just take a look at the numbers, where we can see that according to the UN and the World Bank, approximately $40 billion is stolen in developing countries per year. So you can just imagine what this amount could do in those countries to build infrastructure, hospitals, schools, and in general terms to increase the standard of living of its people. Perhaps that is why the General Secretary of the UN considered this a failure of accountability and transparency that in his capacity of General Secretary of the UN, he cannot let persist. The next slide is in terms of the costs of corruption worldwide, as if we needed further numbers to make this point. But clearly, this is not a disease that is spread out only in the developing countries. So just take a look at what the World Bank Institute estimates that is paid in bribes around the world. This figure is $1 billion. Also, the Asian Development Bank estimates that corruption can cost up to 17% of the GDP of a country. And if you would like to make some sort of a link between corruption and poverty, just check what the Global Finance Integrity has to say about the flows from Africa in terms of illicit financing. The amount is huge. It's 1.8 trillion. And just to finish up, let me briefly refer to a graphic made by Transparency International. Transparency International, as you might know, is a very well-known and reputed international organization. According to them, the perception of corruption in the world ranked within the lowest levels of corruption, the top 5 countries as the following. This is New Zealand, Denmark, Finland, Sweden, and Singapore. And the 5 countries with the highest corruption levels are Afghanistan, Myanmar, North Korea, and guess who is the country with the highest level of corruption? This is Somalia, who happens to be also the poorest country in the world. In our next slide, I'm going to briefly talk about the International Anti-Corruption Treaties and Conventions. You can see these 3 treaties and conventions which are very well known, but I would say that among those 3, the OECD Convention on Combating Bribery of Foreign Public Officials in International Business Transactions, which is known as the Anti-Bribery Convention of the OECD, I would call it as the queen of the international convention, not only because it establishes legally binding standards to criminalize bribery of foreign public officials, but because it also provides for a number of measures to make this effective, as well as measures specifically related with the enforcement of these provisions. The other important feature of this convention is that it also requires member states to adopt and implement mechanisms to prevent and sanction the corrupt activities that occur within their own countries. Another very important convention, in addition to the Inter-American Convention Against Corruption, is the UN Convention Against Corruption, which is also a landmark development for global action against corruption, because it also establishes agreed standards and methods for international cooperation, as well as local efforts to combat corruption. And on a final note, prior to passing it out to Carrie, I will briefly refer to the efforts being made by the IBA, the International Bar Association, which has been requested by the UN, the OECD, and the World Bank to publish a book containing the guidelines for entities around the world to enforce anti-corruption policies. This book is called Anti-Corruption Compliance Handbook for Business, and I am lucky enough to be working with a group of experts from around the world on this panel, and we expect to publish this book in March of next year. If anybody on the audience is interested, please send me an email, and I'll be glad to circulate that. Having said that, I think that the table is set for you, Gary, to take it on the overview of the Foreign Corrupt Practices Act.
Wonderful, Hugo. Thank you very much. That was very helpful, and it's always good to have the perspective on the international framework we're dealing with and the environment. Just add to Hugo's point about Somalia and other top 5 countries in terms of corruption. What the U.S. Department of Justice has said is that they feel the FCPA and OECD efforts to encourage countries to enact excellent and enforce strongly anti-corruption laws is really based on a number of desires, including a recognition that corruption erodes public trust and it can weaken democratic institutions. And certainly in the countries that we heard from Hugo as top in terms of corruption, we can see the connection there. There's also the need to fight organized crime, and anti-terrorist groups can use, or terrorist groups I should say, can use corruption to have negative impacts on others, including their neighbors and international community. So it's a very important effort. The U.S. effort is promulgated within the statutory authority of the Foreign Corrupt Practices Act, and since many of us here are lawyers, I thought it would be helpful to have the legal citation. Interestingly, the Department of Justice, which is responsible for enforcing the FCPA, has not developed guidelines or guidance specific to their efforts in terms of enforcing the FCPA. There's been a lot of discussion about guidelines and guidance being developed and disseminated, but it still is not visible. You can compare that to the UK Bribery Act, and the UK government, which enacted that legislation about 2 years ago, has already in fact implemented and circulated guidance. So we're still hopeful that our DOJ will do the same, but it's still in the offing. Wanted to also mention that the FCPA has been in place for over 35 years, and just a very quick reference to a personal connection to its enactment. I'm not sure this is great news, but the personal connection is my dad was with Esso at the time, now Exxon, when the company was involved in some improper dealings in Italy. And my father was in the Public Affairs Division and got wind of a Department of Justice and congressional concern over those activities, and needed to help the company work through what became a very embarrassing and troublesome set of circumstances. And it was by virtue of the Congress's and the Department of Justice's concerns about that activity, which at the time was not illegal, that we see now the FCPA, or the result being the enactment of the FCPA. Okay, so there are 2 basic prohibitions under the FCPA. There's an anti-bribery provision, which you'd all expect, and in a nutshell, it prohibits or provides for the prohibition of the offering or the payment of anything of value to a foreign government official for purposes of obtaining or retaining business. And this would be activity undertaken by U.S. persons or even non-U.S. persons on behalf of U.S. persons anywhere in the world. And the second basic provision is a books and records provision, which applies only to U.S. publicly traded companies. So we won't go into that in great detail because I don't think in the Meritas world we're representing a very large number of public companies, but suffice it to say that this books and records provision is very important and is certainly used by DOJ to enforce against publicly traded companies when those companies have failed to keep accurate books and records pertaining to payments made. So to the extent you are involved in advising publicly traded companies, this would be a very important provision. For now, I will stick with these anti-bribery provisions. And again, in a nutshell, they prohibit corrupt payments of anything of value to foreign officials for the purpose of obtaining or retaining business. And I've underlined the key terms here, and in the next few slides we'll go through definitions so that we can really unpack this provision, which is the centerpiece of the FCPA. A corrupt payment is defined here. I won't read the slide, but there must be intent to influence a foreign official. If there's a lack of intent, arguably there's no violation. It's not that they need the individual that's providing the payment or offering the payment needs to know the FCPA exists, but they do have to have a corrupt motive. We have seen in certain cases in the U.S. The Department of Justice enforce where they haven't even been able to prove intent. So we're finding the intent element not to be terribly important, at least to the DOJ. It's an important element of defense if you're faced with defending a FCPA enforcement action. But in reality, there should be intent, and it's for the purpose of influencing that foreign official to act in a way that violates his official duties. There doesn't need to be success. So just an attempt to obtain or retain business would be sufficient to meet this element. Anything of value is another term which is used in the prohibition, and it's worthy of some discussion and some understanding. Truly broad in its scope, in that it can be anything from cash to entertainment to even a charitable contribution. We see a lot of issues in the FCPA and analogous non-U.S. regimes where there are tickets to sporting events, nice dinners out, lodging, even these sort of charitable contributions. I'll give to your favorite charity if XYZ. Those sort of offers or payments of value all fall into this term. A foreign official is another term that's critical to understand, and it really is very broad potentially in scope. I'll use China as an example where we are particularly concerned when we have U.S. businesses doing business in China. So many of the institutions in China, and I'll add Russia and some other countries, so many of the individuals you deal with seemingly at a business level are in fact connected with institutions or employed by institutions that are government-owned or managed. In Russia, we deal sometimes with companies that are ostensibly private, but in fact the Russian government holds what we call a golden share, a share that, if it's exercised in terms of voting, controls the company in one way or another. And that can result in every employee, even rank-and-file employees of that company, being a government official, or I should say a foreign government official. As the fifth bullet points out here, rank does not matter. Low-level employees are included. And again, one of the issues we deal with. I'll get in later to some best practices, but one is highlighted here and feel it's important to mention in this context, and that is that family members and spouses of employees of government institutions or of foreign government officials should be treated themselves as foreign officials. We have seen a number of cases where there's been enforcement brought against companies that have not paid directly to a foreign government official or offered to pay, but to their family members, and that can be equally problematic. So it's a wise to the wary, or a word to the wise, I should say. There are also instrumentalities, government-owned or government-controlled companies, which I mentioned a little bit earlier. So we want to be careful with employees, representatives of any of these sort of instrumentalities of a foreign government. There are some exceptions, or really a primary exception to the FCPA, and that is with respect to facilitating payments. And I won't go through this in detail here because Ugo will pick it up in the next piece. But this can cause a great deal of confusion. A facilitating payment would be a low level, in terms of dollar amount, payment for a routine government action. What I like to use as an example is, wanting to get further up the line in terms of receipt of a permit, not whether the permit would be issued or not, but the timing of issuance. If you're in a rush and you really need that permit, facilitating a low dollar amount payment to an official to advance in the line can be permissible. But as you might guess, this can be one of those gray areas that can cause a lot of concern. So there is a best practice I'll address later, which is not even to allow facilitating payments by your employees, or if you're a company, a U.S. company doing business, say in Mexico, have a prohibition against even facilitating payments. But that's a best practice and just a recommendation. Interestingly, just to compare, the UK Bribery Act does not even permit facilitating payments. There are a couple of affirmative defenses which are outlined here. If the payment was lawful under the written laws of the foreign jurisdiction, this gets more and more interesting as more and more countries enact analogous statutory provisions, like Russia and the UK recently. Again, one of these defenses we'd really rather not have to invoke. And there is an important affirmative defense also in terms of the expenditure to demonstrate a product or perform a contractual obligation. This we do use on occasion, particularly where a foreign government official needs to visit the U.S. to view a production facility or to have a product demonstrated to him or her prior to potential purchase. Again, there are a number of best practices and improper practices in relation to this sort of conduct, which I'll address a bit later. But this can be a useful exception, so to speak. This slide addresses, what we mean by kind of reasonable bona fide expenditures. And again, I won't go through it in detail, other than to say it really needs to be a low-level amount. We generally say no more than $100. We do need to be concerned about cumulative payments of these small expenditures and what they add up to ultimately. So it can be an area kind of trap for the unwary. And again, under the UK Bribery Act, there is no such exception. One of the key areas we find enforcement issues is where a foreign representative or a non-U.S. representative of a U.S. party engages in behavior ostensibly on behalf of the U.S. party, but perhaps unknown to the U.S. party. So if you have a sales representative or a commissioned sales agent, or even someone that doesn't have a sales function but is representing a U.S. company or U.S. party in some way in a foreign jurisdiction, their behavior again, even if unknown to the U.S. party, can negatively impact the U.S. party. It can constitute a violation of the FCPA. So here we're very careful about advising our clients about doing proper diligence on their foreign sales reps and agents and representatives. There are a number of red flags in terms of where business might be done, where corruption might be a particular issue. I think Ugo pointed out correctly that there are these top 5 and bottom 5 sort of countries, and then everyone in between. It used to be that these BRIC countries were really considered by far the most dangerous countries to deal in. I'm not so sure that's still the case, but nevertheless, you do see China here and you see Russia, which I've mentioned. Those countries still are of concern, but they're moving in the right direction. Just kind of another tip that if you're dealing in these countries or the countries identified by Ugo earlier, worthy of particular care and attention. There are also problematic industries: defense, oil, construction, and aircraft. We've seen the most. We're also seeing in the pharmaceutical arena a lot of enforcement actions. What happens with the Department of Justice in the U.S. is they tend to focus on particular industries at any given time. They'll do one enforcement action and then several more within that industry will follow quickly. So when you see one coming down the pike for a new industry, you can expect there'll be additional. Certainly dealings in cash is another red flag and something to be wary of. Needing to do your diligence on the foreign representative being very important, and the reaction to that diligence should be measured and calibrated. If they refuse to make representations that they will abide by both the FCPA and their local law, obviously that is a very large red flag. And then outlined here are a number of defenses that we know don't work. The sort of defenses a child might use with their mom. Well, Jimmy did it, so why can't I, sort of thing, obviously is not a good defense. Some others that are interesting, only the big companies get into FCPA trouble. It's really a misnomer. While you see the most press on the largest company enforcement actions, there are a number of smaller and even smaller companies and individuals that are saddled with significant penalties for noncompliance. Also, the notion, I think it's about 6 bullets down, we can't control what our agent does on his own time with his own money, is very much a defense that won't work, and it's a misnomer to think that ignorance of that agent's activities would be a viable defense. I'll leave it at that as your basic overview of FCPA and bring it back to Ugo for extraterritorial and facilitating payments.
Thank you, Gary. I think that has been very useful, and the materials also provide very, very important information. I'll have to admit that the extraterritorial reach of the FCPA has always been an issue, particularly for non-U.S. lawyers or for entities that do business outside the United States. And perhaps due to our involvement on the compliance and anti-corruption issues, we have been asked over and over again the question of, is FCPA enforceable outside the U.S.? And I'll have to admit that that is a tricky question, because the short answer is no. The FCPA is only enforceable in the U.S. But if you are listening to this webinar outside the U.S., as I see a number of non-U.S. phone numbers, before you leave or hang up, let me tell you why it is very important for you and your clients and for any company that is doing business outside the U.S. to clearly understand what is the extraterritorial reach of the FCPA. And let me start by saying that basically the reach can apply in 2 scenarios. One, and they're relatively simple and easy to understand. One is based on territoriality. This criteria is pretty simple. It applies to anything that actually happens on U.S. soil. regardless of the nationality of the entities or individuals involved. That's one. The second one, nationality, is also very simple to understand because it applies to U.S. entities or individuals who get involved in corrupt practices anywhere in the world. Well, the question is, if those criteria are simple and if my client does not qualify in any of those two scenarios, why should I be worried about the FCPA? Let me tell you why. Foreign companies might be subject to what we call the expansive power of the FCPA by a number of other means. For example, foreign issuers registered in the U.S. Stock Exchange. For example, any foreign company who sponsors ADRs on the U.S. Stock Exchange. As you know, an ADR is a stock that trades in the U.S. but represents shares in a foreign corporation. And this is important because currently there are more than 2,000 foreign companies registered before the SEC or doing business with the U.S. Stock Exchange, which will be subject to the FCPA. And also, more importantly, listen to this. Using wire transfer between foreign bank accounts that are cleared through correspondent accounts in the U.S. will be considered sufficient links. So as you can see, the concept of sufficient link can expand quite far. And as an example of this, maybe on what is the best known case or recent FCPA case, of course after the Walmart case that we will briefly discuss in a few minutes, is the Siemens case where the SEC and the DOJ charged Siemens AG, which is, as you know, a European company, and three of its subsidiaries, which are Argentina, Venezuela, and Bangladesh, which resulted in Siemens having to settle charges against it for more than $800 million. While on one side, it is very easy to understand why Siemens got in the hook, because it sells securities in the U.S. and clearly falls within the jurisdictional reach under the territorial concept. The question is, why did the three foreign companies with headquarters in other countries, which had apparently nothing to do in the U.S., why were they subject to the FCPA? However, the U.S. government established jurisdiction over these subsidiaries in part because U.S. bank accounts were used to facilitate improper payments. So the basis for asserting jurisdiction on this case, which honestly can happen anywhere in the world, to any company anywhere in the world, is that according to the FCPA, non-U.S. persons are prohibited from using what they call U.S. mails or any other means or instrumentality for payment of any corrupt money to any foreign official. So as you can see, the liability under the FCPA does not end with U.S. persons or businesses, but includes entities and individuals of any citizenship that take any business action with any sort of link with the United States. Just think of today's interrelated business environment with worldwide electronic communication, how interrelated the financial transactions are. Well, clearly the reach of the FCPA can extend to your clients, and they might be subject to the FCPA. That's why you need to be aware of the existence and the application of the FCPA that can clearly reach your clients and your companies, regardless of the fact that you feel that you do not have enough links with the U.S. Well, don't get me wrong. I mean, I strongly believe that the FCPA has been instrumental and has been very helpful in reducing the levels of corruption in a number of countries of the world. It is just that as non-U.S. attorneys in a number of legal forums, the outreach and the extraterritorial reach of the FCPA has been questioned, and I believe that it was important to share this view. Another matter that is interesting to keep in mind is that any entity can be considered to have violated the FCPA for any actions that any of their officers, directors, employees, or agents, regardless of their nationality, have taken if they are linked to any sort of corrupt practices. This has special interest to the Mexican subsidiaries that represent U.S. entities, that anything that happens not only in Mexico but in any subsidiary of the U.S. company anywhere in the world, as Kerry was mentioning, will eventually represent a violation for the U.S. company, and a defense would not be that they didn't have enough control over what their foreign subsidiary was doing. The concept of facilitating payments also for non-U.S. attorneys is kind of difficult to understand why it is an exception of the FCPA. I would say particularly since there is not a dollar limit. And even when a number of companies already prohibit this type of payment, and I guess that the reason is that there is a very thin line between what can be considered a facilitating payment and what can be considered as a bribe. Kerry already mentioned that there are certain requirements to be met in order for this to be considered a facilitation payment. Basically, these are payments to government officials to expedite or secure the performance of routine and common government services and functions. And I think that Kerry also mentioned something very important, which is that the foreign officer needs not to use any discretionary authority to grant or deny the permit, because if it reaches the level of a governmental officer which has sufficient authority or discretion to do so, then it will be very difficult, in my view. I don't know, Kerry, you are the U.S. attorney here, but it will be very difficult, in my view, for a company to get away with that to be considered a facilitation payment. Just as a matter of comparison, under Mexican laws, facilitating payments are illegal with one exception, which is if they do not exceed $55 per year. And the funny thing that is in Mexico, it is an exception for the foreign officer, so the giver is still on the hook. I mean, I leave you that for further consideration. Now that I'm speaking of Mexico, there are a number of anti-corruption laws and initiatives that have been enacted recently, which I understand and assume that would be of interest for the number of the Mexican attendees that we have on this webinar. A very recent one, which actually was enacted this month and is expected to become effective next year, is what we call the anti-money laundering law. This law basically has a purpose of, can we say, gather the cooperation of all of the individuals involved in the financial system and other key areas such as real property firms, including law firms and other related firms, who require or who will now be obliged to notify to the authorities of certain cases that are considered questionable, vulnerable, or that might relate to some way of money laundering. And this is in Mexico, this is viewed as another important effort to prevent the proceeds from illegal activities to enter into the Mexican financial system. Basically, in one of the information on what was the reason why the Mexican authorities enacted this law is that between September of last year and October of this year, the tax authorities identified almost 40,000 questionable financial transactions. And in Mexico, we are hopeful that this type of initiatives will contribute to keep reducing not only the money laundering, but the corrupt activities entitled to it or related to it. Another very important one, which became effective in June of this year, is the anti-corruption law for public acquisitions. We also have the Federal Criminal Code and a number of other laws that prohibit corruption and prosecute both the offender, which is a bribe giver, as well as the passive offender, which is the one receiving the consideration, which is another difference between the FCPA and the local regulations in Mexico. The FCPA only goes against the offender. One of the interesting initiatives here, to which I will have to admit that I have been pleasantly surprised by our President-elect, Mr. Peña Nieto, is the creation of the National Anti-Corruption Commission and the significant expansion to the authorities of the IFAI, which is the institute that has to do with transparency and access to the information. Carrie, I'm moving to the case studies, but I would like to know if you would like to interject with anything I said about extraterritorial application or facilitation payments under the FCPA.
No, Ugo, that was excellent. I think you covered it very well. I guess I'll just make a tangential comment, which is that in the world I deal with every day in international trade, I also confront the reality that U.S. export control laws apply extraterritorially in a way that's different from every other country's application of its law. I won't get into that subject here because it's a whole another realm that we could deal with for another couple of hours. But suffice it to say there is extraterritorial application in other areas under U.S. law, including export controls. Okay, perfect. Thank you, Kerry. With that, I'll move to our next slide, which is a case study, which will be interesting to share with the attendees. And basically, we recently had a case where a Mexican subsidiary of one of our clients was in negotiations with another Mexican company who was about to participate in a public bidding process with a Mexican agency which is in charge of the infrastructure in federal roads and highways. Our client has the technology and the equipment to be installed in what we call the casetas, I guess in English would be the federal toll roads, and it's pretty much a leader in the field. However, as part of this process, the Mexican company with whom they were doing business, their plan was to participate in the bidding process and pretty much after obtaining the contract to hire our client as a subcontractor who, as I said, had the technology and the infrastructure to install those particular items on the federal roads. However, in the course of the negotiations, both our clients and one of our partners realized that the Mexican company was owned by former politicians who were somehow involved in the political campaigns, in the recent political campaigns in Mexico. And not only that, but as a result of some of the negotiations, there were reasons to believe that part of their political influence was expected to be used to obtain a favorable bidding process, because apparently they had some relationships with high-level officers of the entity organizing the bidding process. One of our partners was involved in the negotiation, and pretty much she was a whistleblower who contacted, well, first the general counsel of our client in the U.S., who unfortunately happened to be on vacation, so that didn't allow him to react promptly and as quickly as the urgency of the matter required. So 2 days later, we were in a position to have to insist on that, and our partner had to blow the whistle again, but now with the CFO of the company, who immediately, realized that, by only attending a meeting where there was some sort of implication that eventually political influences would have been used in order to win a contest or a bidding process, they requested to immediately suspend any communication with the Mexican entity and hired an expert firm from Washington, an FCPA expert firm in Washington, who immediately conducted some interrogatories and investigations, which were, according to our partner who participated in that, particularly hard. They requested copies of every note taken, every conversation, everything related with the meeting, the attendees and stuff. And as a result of the weeks of investigation, the outcome pretty much was that our client did not violate nor any U.S., nor international, nor any Mexican anti-corruption laws, that our partner reacted properly by blowing the whistle. Unfortunately, the general counsel was terminated, and since then, the company implemented very clear policies on what to do and what to do in this type of meetings, because at the end of the day, and I know Kerry will touch about best practices, but having local employees duly trained on how to react on certain circumstances is key to avoid exposure to FCPA matters. Then I'll move it on to the probably the sexiest FCPA case, and I'm sure you all know about it, so I will be very brief on the introduction. But for those of you who do not remember, on April the 21st, the New York Times published a report
and an article about Walmart de Mexico, saying that Walmart, a senior lawyer, received in September 2005 an email indicating that apparently there has been quote, an orchestrated campaign of bribery to win market dominance in Mexico, and that in its rush to build stores, the company had paid bribes to obtain permits in virtually every corner of the country. This is what the New York Times says. Basically, an investigation was initiated by Walmart then, and they found apparently hundreds of documents that prove that approximately $24 million were spent in questionable activities related with the obtaining of permits to open stores in Mexico. The interesting thing is that Walmart's lead investigator, who was a former FBI special agent, in a report he said that there's reasonable suspicion, quote, to believe that Mexican and U.S. laws have been violated. And what the investigator did is he recommended Walmart to expand the investigation. But for some reason, instead, Walmart's lead shut the investigation down. So that is pretty much what has been in the public press. But my idea was to focus this more onto what really happened from the Mexican perspective. Many of us who deal with obtaining permits and licenses in Mexico know that, for example, a number of urban development plans, zoning regulations, environmental permits, and a number of other things are required in order for a construction permit to be issued, and that we face a number of legal and bureaucratic obstacles in order to obtain these permits for our clients that in many instances, unfortunately, can take months. What happened here is apparently not only payments were made, and I said apparently because obviously I have not seen the evidence, but I have sources that consider this to be the case, that in addition to the expediting payments or the facilitating payments, there were payments made, just consider the amount, $24 million, that actually were made to officers who had enough discretionary authority to grant the permits, and not only that, but to modify zoning, urban development plans, and eventually alter some environmental impact studies, because clearly in some of the locations where the stores were built, it was only a residential area that now allows for a commercial building, such as a Walmart case. This is a very, very interesting case, which basically has a lot of attention, not only on the legal profession in a number of countries in the world, but I mean, this will set, and correct me if I'm wrong, Kerry, but a very important precedent on the FCPA enforcement. So there's a number, I would say, of people around the world expecting to see what the outcome of this is, because there are a number of questions that are raised here. Whether the payments were to be considered facilitating payments, I mean, if $24 million can be considered within the scope, even though FCPA does not establish a dollar limit, I personally doubt it. There is an issue also of the Statute of Limitations, which I will let Gary talk about that if need be, but I doubt that they will go away with it, because even though this happened in 2005, there are occasions where the extension of the 5 years can apply, and I believe that this will be one of them. The affirmative defense of these payments to be legal in Mexico will not fly, because these payments are not legal in Mexico. And the big question is whether or not they were reporting on the accounting books all these matters. So that remains to be seen. The good news is that Walmart has significantly solidified its anti-corruption team. Javier Soni, who has been appointed as the Director of Compliance, is a former partner of Pricewaterhouse. I know Javier, and I actually spoke with him in preparation for this webinar. We exchanged emails with him and his partners. And clearly his strategy to approach this sensitive matter is to strengthen the compliance programs, to do more due diligence on the business partners, and to supervise a professional devoted to obtain permits and licenses. He has, in fact, already hired external counsel and an FCPA and a CPA firm which luckily enough for his own credibility was not Price Waterhouse, which was his former employee, but it was KPMG. So this is a wrap-up of the Walmart case. If there are some questions, I'll be glad to respond it afterwards. And with this, I'll pass it on back to Kerry.
Excellent. Ugo, thank you very much. I will just give a quick point on the statute of limitations issue. I think, Ugo, what you're referring to in terms of there potentially being a longer statute than 5 years is the concept that it can be extended to 7 years under certain circumstances, which I think probably would apply here.
Okay.
So yeah, we're looking at up to 7 years in these sort of activities as a look-back period. Okay, we only have a few more minutes, and we do want to leave a couple at the end for questions to the extent anybody wants to present them. So I will go through the remaining slides rather quickly. They're substantive, so certainly can serve as reference in the future. There are 5 total that I'll cover here on best practices. Certainly, I would say a best practice and really a necessary practice is a company that's engaged in international activities developing a good compliance policy and program, and that the commitment to compliance start from the very top. That is a common theme in enforcement actions, and it's a reality that companies that have strong leadership from the top in terms of setting a compliance tone and demanding compliance of employees is really necessary. Having bright lines and having clear internal controls is another facet. And again, without a written compliance program and policy, it's hard for us to see companies having these bright lines and these clear edicts on what can and cannot be done. The third bullet here details some of the key pieces of a compliance program. They're not, it's not an exhaustive listing, but certainly these are the key parts. Having hypothetical examples of what is proper and improper activity within a particular company's business can be very helpful, we find. So we like to have these hypothetical examples embedded within the written compliance program. And then train, and train again, really against the written compliance program and using the hypothetical examples as learning tools and almost create a quiz sort of format. Is the hypothetical example of conduct appropriate or inappropriate or legal or illegal under the FCPA? Another best practice around facilitating payments, not to exceed $100, what Ugo referenced as a $55 threshold. Those are important thresholds to know about under local law. Under the FCPA, there is no bright line here, but our best practice edict is generally along the lines of 100. Less is better. Frankly, in the compliance programs that I suggest to clients, I always start with a no facilitating payment sort of edict. If they are determined to be allowed to exercise certain facilitating payments or certain low-level facilitating payments, then what we do is we have a central individual responsible for vetting those payments before they're actually made. Third-party relationships, as I mentioned earlier, the activity, the conduct of a third party abroad can absolutely negatively impact a U.S. company and vice versa for Mexico. So very important to know who you're dealing with and to choose outstanding individuals and persons that you can trust and vet them carefully. If you can get recommendations and viewpoints of those that have already worked with them, that's always helpful. Certainly having strong contractual provisions, very helpful. My firm was recently helping a company through an FCPA issue, and we did a voluntary disclosure. And one of the first questions back from DOJ was for us, or request was for us to provide copies of any contracts that contained FCPA compliance language. We were happy to have some of that, and the company didn't have really enough historically, but that was evidence of part of the historical problem, but not the current effort to comply. And 2 more slides on best practices. Where there is acquisition activity, where one of your clients might be considering the acquisition of a company that has foreign operations, we consider the FCPA arena to be one of those key diligence areas, and the need for a reasonable level of investigation of the past activities to get comfortable, and certainly some standard questions that can be asked, but following the leads that might be provided and not leaving significant issues unresolved prior to acquisition, I think is certainly a best practice. And self-reporting, unlike some statutes in the U.S., like the U.S. Export Control Statutes, EAR and ITAR, there is no definitive statement of or method of voluntarily disclosing a violation of the FCPA, but there is a long and convincing history that voluntary disclosure, self-report of past suspected or actual violations of FCPA can go a long way to mitigating penalties. Certainly would be viewed very favorably by DOJ versus a situation where they are the discoverer or some third party is the discoverer of the wrongdoing. In those circumstances, certainly DOJ's wrath would come down pretty hard. But with a voluntary or self-report, you have the best chance of mitigating the penalties. Certainly the internal investigation needs to be thorough and honest, and the report needs to not hold punches. If problems were found, it's best to disclose them fully and accurately, and make your pitch for why penalties should be reduced or non-existent. With that, I see we have 2 minutes left, which isn't a lot of time for questions, but we'd be happy to answer a couple.
Yes, Gary, I see a question that says, what does the FCPA say about payments to non-governmental officials? It says, are we assumed that a manufacturer is free to bribe a subcontractor as long as they know they're a private individual? I will briefly respond to that, and I'll pass it on to Carrie for you to further elaborate. Basically, the FCPA applies only for corrupt practices with foreign public officials. It is different than the UK Bribery Act. The UK Bribery Act does contemplate this type of what they call private sort of corruption. That is the short answer, Carrie, but I would like for you to elaborate further on this.
Yeah, that's correct, Ugo. And interestingly, the UK Bribery Act does have that private corruption sort of provision. Under the FCPA, there is no such prohibition. There's no legal prohibition. Where we do find problems on occasion are where it's a public bidding sort of situation. But that often involves a foreign government official or a government official in the first place, and there are specific prohibitions in those bidding statutes. But under the FCPA, it's part of doing business, I suppose, is the view.
Okay. Kim, I guess it's time. I don't know if we would allow for one more question because our commitment was to be online for 60 minutes.
Yep, no, absolutely. Well, would definitely like to thank you, Ugo and Carrie, for your wonderful presentation today. Thank you for all of your insights and sharing your knowledge in this area. Should any other questions arise, Ugo, Carrie, I imagine you would be available afterwards if any of our attendees today would like to contact you by phone or email. And I also wanted to let everyone know that participated today. We will be circulating a copy of the presentation as well as a link to today's recording. So that will be coming to you within the next couple of days. So with that, Ugo, Carrie, is there anything additional you would like to add?
Yeah, this being Carrie, just want to thank everyone for attending and hope that it was helpful. I see Marco's asked a quick question about China and best practice, whether to assume that in the construction industry, every individual you're dealing with in China is a government official. And that's not a bad assumption. I think it's especially in China better to assume government official and then seek to disprove than to make a potentially dangerous assumption the other way. But thank you all for attending.
Wonderful. Thanks again, everyone. Bye-bye.
Thank you. Thank you all. Bye-bye.
Thank you. Please stand by.